Mr. Gomez, you have 3 minutes.
Great. Hello there, Commissioners. How are you great folks doing today? Good? Happy New Year. Another year where you're going to have to make choices of, good, bad, reviewing things. And hopefully, somehow we can change the Police Oversight Commission process, with the IRO and with the CAO, controlling the IRO and all that. So I'm just wishing that everyone here will do the right thing and review all these cases extensively. Still question about the lapel cameras. I'm sure, I haven't been here a few months, but I'm sure you've been looking at that too. All the excuses, all the usual stuff with the lapel cameras. And just be wise and be truthful, and hopefully we can make it 2014 a better year for everybody. Thanks.
Thank you, Mr. Gomez. Okay, we move to review and approval of the December minutes.
Mr. Chair,
Commissioner Stein.
I have 2 corrections to make in these minutes. On page 3, the top paragraph after on the appeal, before the vote is recorded, I think we need to add the sentence "motion failed." We usually say passed or failed. So that
I'm sorry,
means
can you tell me again where you are?
I'm on the 3rd line from the top of page 3. After it says, Commissioner Barker moved to uphold the findings of the IRO and deny the appeal, it should say motion failed.
Okay.
And then the small typo, 4 lines down, the cease and desist letter was received from the union, not by the union.
Okay.
With those amendments, I move to approve the minutes.
Are there other? Commissioner Siegel.
Thank you. There was a motion made. Can that be taken off the table?
Yeah, I'll withdraw it.
Thank you. On page 2, under CPC 236-12, I would recommend changing the wording in the second to last line and the last lines as follows. It says to be able to review, and it says, and I would suggest that we write instead to permit the IRO to review the evidence produced by Mr. Hernandez and then to recommend its admissibility to the commission.
Okay. Is there any question about that? Everybody understand that?
Could you repeat it? I'm sorry, I missed it.
Certainly. I propose to revise the last phrase to read instead, to permit the IRO to review the evidence produced by Mr. Hernandez and then to recommend its admissibility to the commission.
Everybody got that? Okay. Commissioner Foster.
Could you expand upon that a little bit, Commissioner Siegel, as far as to recommend to us? Are you saying that some evidence she should be privy to that we should not be?
Yes, at the time that we began this, it was an appeal. The appellant offered 4 items of evidence for our consideration. We didn't know whether we should accept those items or not. And I think it was decided that the evidence would be given to the IRO for the IRO's review and consideration, and then that the IRO would recommend, well, if you prefer, its admissibility or non-admissibility to the commission. And that was how I understood we had left the matter. And in this instance, it just says to be able to review the evidence, and we haven't seen it or reviewed it. So I'm just trying to clarify that piece of the minutes.
That's as I recall it. Anything else? Okay.
Can I move, Mr. Chair?
Commissioner Shine.
Could I now move to approve the amended minutes, including not only mine, but Commissioner Siegel's amendments?
Is there a second? Second. Commissioner Peterson? Any discussion? All in favor, please raise your right hand. It is unanimous. So with those amendments, we will approve the minutes. Okay. Move to citizen appeals. The first one is CPC 236-12, continued from our December meeting.
Perhaps you could go over the procedures before for the appellant.
Here it is. I failed to bring my rules with me, so could someone else find that? I made it on my computer.
It's on page 11 of the current rules.
Okay, I've got it. Okay, so going over the time frame, the appellant will have 15 minutes to begin. The police officer involved is present. That officer will have 5 minutes, followed by 10 minutes by the APD, 10 minutes for the IRO, and then 5 minutes at the end for the appellant's rebuttal.
Yeah.
Are there any questions?
4. Okay. And what would you be presenting? Did you? You want to play the video during your time?
Yes.
Okay. Just tell me what you want to do.
Mr.
If I could address the commission on the motion that just passed, I do not believe that the IRO reviewed the evidence that the commission just motioned on. In fact, quite frankly, she was very obstructive in assisting.
Okay, let me stop you right there. Ms. Hammer, did you have a chance to review the items that he had presented to us last month?
I reviewed the evidence. I spoke with Mr. Hernandez on the phone regarding his position on why the evidence was admissible. I received and reviewed an email from Mr. Hernandez why he believed the evidence he submitted was admissible, and I emailed back Mr. Hernandez my position as to each of his, I believe, 7 exhibits.
Okay, and
Well,
I don't have, did you copy us on that, or?
On the email?
Yeah.
No, what happened, it was, I never heard back from Mr. Hernandez as far as, I told him I had objections because the officers' names were in some of the exhibits, in fact, all of them. And so I would need to see redacted versions if he were going to submit them, and that if he were going to present matters, his documents to the commission, certainly, I agreed to one piece of his, one of his exhibits, but the rest of them I gave the reasons for my concerns.
Okay.
And so it would be up to the appellant if he, Mr. Hernandez, if he wanted to present that evidence to provide copies to you of the exhibits that he proffered, and then we could discuss it before the commission, and the commission can rule. Ultimately, I'm not the arbitrator of whether the commission receives new evidence at appeal, but I'm prepared to argue it at this point, as opposed to last month when I hadn't received them.
Okay.
And may I pose a question? Was the motion that just passed forward to review and consider in relation to the complaint, or was it simply to review in relation to her objections? Because my understanding was the motion just passed, was that she review it and consider it in relation to the case.
Mr. Chairman?
Yes, Commissioner Shine.
If I might explain, the motion that we just passed was amending a set of minutes from last month. And had nothing to do with deciding anything in relationship to this proceeding today.
Well, it was in relation to my exhibits, was it not?
No, but it was amending the language in the minutes from last month. So it does and will have no impact on what happens today.
Okay, I understood that language would, in my understanding, based on the language that was changed, would allow the IRO to consider it under the investigation. That's what I understood. If I misunderstood that, then I stand corrected.
Okay, do you have your evidence with you?
I do have the exhibits, and again, they're the same exhibits. They are a set of transcripts related to the audio or to the video that you'll witness several times today, probably. And then also an email chain between myself and the IRO investigator. And the email chain simply indicates that I was never interviewed as requested, and as the IRO investigator indicated to me that I would be.
So I'm sorry, Mr. Chair, I'm confused. Originally submitted to me last meeting were 7 exhibits that Mr. Hernandez sought to admit at the last hearing. And it's my understanding from what he said today that he wants to admit 2. So I would just ask the chair to inquire as to clarification where we stand on requests for admissions of exhibits.
Make it a total of 4, as there was one other exhibit, which is, actually I'll withdraw the exhibit. I'll maintain the 3 I submitted for today's purposes.
And I would just ask to find out what 3 are we talking about?
That would be the exhibit A and B, which are the transcripts to the video, which we will see, and the third being an email chain between myself and the IRO investigator, simply indicating that he never conducted an interview as I requested and as he stated he would.
So my understanding is that you're now trying to admit exhibits, Mr. Hernandez is trying to admit formally numbered exhibits 1, 2, and 7.
Okay.
If that's correct, then I'm prepared to discuss that.
Okay, so we should receive those at this point, is that correct? Or-
You should receive them and review them as a commission and determine whether or not you want to receive new evidence.
Yeah.
Because it's not, these records are not currently these exhibits are not in the current record, but under your rules, you may receive new evidence at a hearing.
Okay.
But just because you have them in your possession doesn't make them part of the record until you move to adoption of the new evidence.
Commissioner Foster, you had something, and then Commissioner Siegel.
Yes. Mr. Hernandez, did I hear you correctly saying that you have requested to be interviewed by one of the IRO's investigators and you were not initially, or in relation to this appeal?
No, initially, and the email chain outlines that.
Okay, let's wait till we get to that, then we'll discuss it.
Thank you.
Commissioner Siegel.
Thank you. With respect to the materials we're about to receive, I would not want them to come forward if they name any officers by name. I want to be sure that we don't receive documents that in some way taint this proceeding with respect to the rules that, as I understand it.
And I have redacted the officer's name on the documents.
Mr. Chair,
Commissioner Shine.
may I make a suggestion?
Please.
That before the documents are distributed to us, let's hear both sides on each document, each exhibit, as to whether there's any objection or not. And if obviously there's no objection from the IRO, then we should look at it. But if there is an objection, we should probably hear the objection first and decide that, whether we accept the objection before we look at the document.
Sounds reasonable to me. So let's go with your first exhibit. What is your first exhibit?
Exhibit 1 and Exhibit 2 as they'll be called today, are simply transcripts from the incident, from the video of which the police department has and of which I have a copy and of which you'll witness today. It's, it serves multiple purposes. One, primarily, for me, it allows me, since I have limited time for my presentation to you, it allows me to point out specific facts during the course of contact.
Okay. And Ms. Hammer, did you have objections to either of these exhibits, other than the names?
When they're Exhibit 1 and Exhibit 2, I reviewed the proposed transcript and the video, and I believe that in transcript section, the reason why there are two transcripts is because the officer turns off his lapel while he waits for backup to arrive, and so it's the first encounter and then the second encounter with Mr. Hernandez. So there are two separate lapel videos, which will be shown today. I had objections to the first transcript because I believe that there's a fair amount of statements by Mr. Hernandez on the video, which perhaps Mr. Hernandez knows what he said, but are inaudible on the tape. So that in the transcript there are words and are statements attributed to Mr. Hernandez that I wasn't able to hear while listening with headphones to the tape. So I think it's misleading to say that the officer would have heard and understood what Mr. Hernandez was saying through the window of his car when I didn't hear it.
Okay. Anything else about those two exhibits?
With respect to those transcripts, yes, that's all I have. And the officer's name.
Mr. Chair,
Yes.
may I?
Sure.
Where did this, Mr. Hernandez, where did this transcript come from? Did you have a professional transcriber prepare it?
The transcripts came from my attorney's office, and I don't know if he actually contracted them out, or if he had an assistant do them. I'm unclear, to be honest. But I would make the recommendation that the council accept them. And you can judge for yourself how accurate they are. You will hear the audio, you will see the video, and if you find them to be inaccurate, then you can simply dismiss them, or you can place as much weight on them as you feel necessary. I feel they're accurate. They were not done by me. They're not done to misrepresent anything, and I think you can judge for yourself if you allow the evidence in, very simply.
Mr. Chair,
Yes.
I had a discussion with the IRO an hour or so ago about this issue. Ordinarily, I would agree with Mr. Hernandez that we are the ones who have to decide whether the transcript accurately represents what's on the video. But the problem I have with that, and the IRO pointed this out to me, is that based on past experience, when these videos are played in this room with the limited equipment that we have, a large part of these videos are inaudible. So I'm not sure that we're going to be able to effectively perform that function. This is raised for future appeals, a broader issue, whether we should just ask the IRO to have an independent transcriber transcribe these videos for us. For this purpose, I'm a little reluctant to look at the transcripts, because it's going to be, although I've listened to the video in the IRO's office, it's going to be, I think, very difficult to understand the language in this room when it's played.
Okay. Anyone else? Commissioner Siegel.
I just want to be as clear as I can from you, Mr. Hernandez. When the transcripts were prepared, did you assist the attorney or the attorney's transcriber in any way?
Absolutely not.
You just received them cold, and that was their effort to transcribe?
Yes, and I want to say that the first time I even saw them was when they were served during an ongoing process that I was involved in.
Thank you.
Okay. Any other questions or thoughts about this?
I have a question for Ms. Hammer. Are you objecting to both? Are there parts, because you said you reviewed that there's two separate ones?
I would submit that the second one I don't object to, when he's outside the car. Inside the car, I think it's very difficult to hear what Mr. Hernandez is saying. But nonetheless, they were prepared, even if they weren't prepared by Mr. Hernandez himself, they were prepared prepared by his attorney in support of his position against the officer. The parallel proceeding was an internal affairs investigation done by Mr. Hernandez's employer, which Mr. Hernandez was a party, not an impartial person, so.
And what I would proffer here is that I offered the IRO the opportunity to interlineate on the documents any discrepancies that she felt so that I could, before this hearing, agree to their admittance. And of course, those emails were ignored. Additionally, although I gave those documents to her last month, I did not receive an email from her related to the documents until close of business 1 week ago. And so this is just another example of her stonewalling the exhibits because they do not support her position. And if the council wants to advise her or direct her to interlineate, I would be more than welcome to negotiate with her, but that's virtually impossible with this IRO.
Mr. Chair,
Commissioner Ham, Ms. Ham.
I would submit that I told the commission at the last hearing, which wasn't reflected in the minutes, but I said that I would have my position back to Mr. Hernandez on January the 2nd after the holidays, and that's when I gave it to him, as I said I would on January the 2nd. And it was about 1 in the morning, I believe, this morning, that the request for the intermediation part came up.
Okay.
Mr.
Commissioner
Mr.
Finn?
Chair, I move that we accept the transcripts, and let's have a vote on
Okay. Commissioner Barella, seconded. Is there any further discussion? Commissioner Siegel?
The only other thought I have on the matter would be, if there are only a few phrases, I have no way of knowing how much of this is in question. And if there are only a few, those could be put in brackets, parens, or some other mode of showing us that these are the areas in any question, so that we can understand what parts are not disputed and what parts are. And I don't mind even waiting another month if it takes that, to have as many hearings as we know how, with IRO Hemmer's objections pointed out and our best understanding possible of this evidence.
Any other discussion? Okay, Commissioner Foster.
Point of clarification, we are voting on survival. Yeah,
Lean up to it.
okay, yeah. I'm under the impression that we are going to just accept the transcripts for our consideration. Is that
That's
correct?
correct. That's the motion.
Thank you.
Okay, the motion is that we accept these two exhibits, the transcripts. Ready to vote? All in favor, please raise your right hand.
it.
So
Mr.
that's
Chair,
unanimous.
at this time, I'd like to make another motion,
Okay,
if I may. I'd like to make, since as I understand, the transcripts are not annotated as Commissioner Siegel suggested, I'd like to move that this matter be continued for another month, so that in the meantime, there can be the IRO can indicate on there what she thinks is inappropriate and bracket it in some way, and so then we can at least know what we're looking at when we look at the transcript.
is there a second to the motion?
I'll second it.
Commissioner Siegel seconds. Any discussion? Yes.
Before we move on, I would like to hear about the last exhibit that was in question so that we can formally understand and make any corrections we possibly can to the last exhibit that wants.
Well, I'm sorry, we've got a motion on the floor at this point. We need to vote.
Correct, I'm the seconder and I would like to amend the motion and better understand, if possible, the ramifications of the last piece of evidence. Otherwise, we could come here in a month and wonder what's going on with the third piece of evidence that is offered.
Mr. Chair,
Yes.
I agree with Commissioner Siegel, so I'll move to table my motion until we can have that discussion, and then we can take it off the table and amend the motion.
Okay, is there, all in favor of tabling the motion, please raise your right hand. It's all opposed? Commissioner Foster abstains. Okay. So let's hear the third, Ms. Hammer, if your objection to his third, or do you have any objections to his third piece of evidence? Or
His third piece, I would just base it on relevance. There is, Mr. Hernandez contends that he was never interviewed by an investigator in my office, when in fact we have 13 minutes of a recorded conversation between Mr. Hernandez and an investigator in my office regarding the facts of the case. When Mr. Hernandez got back for a second time asking, when he got back a second time, the 90 days had passed.
In essence, she's proffering
Excuse
and
me.
arguing the
Excuse me, I'd like for her to finish.
These are my objections, it's just based on relevance, that what the emails tend to, or would show, whether or not they're relevant in this case, when in fact an investigator did interview Mr. Hernandez, did not interview him a second time as was discussed, but the subsequent email chain occurred 90 days through time of investigation had passed. So I would submit that their relevance is very limited, but I don't oppose a receipt and then the commission to vote on whether or not they are relevant to be entered into the record.
Okay, Mr. Hernandez.
Well, the documents are relevant because during my short telephonic interview with the IRO investigator, I was basically accused, he was accusatory, and it was not a situation of which I could offer detailed explanation of my complaint. Thus, the very day, right after that interview, I contacted him telephonically and requested to meet the next day in person to conduct an interview, of which he responded that he would review the video and then contact me so that we could schedule that in-person interview, of which I was never contacted for. Additionally, it's very possible that I could have provided the IRO office with additional information pertaining to my complaint that could have further clarified my complaint and provided evidence to support it. And so the email chain is very clear. I requested an in-person interview the following day because the IRO investigator was nothing but accusatory over the phone. And in essence, basically accused me of being a drug user and suggested that the officer should have conducted a DRE investigation during my arrest. So in essence, he's acting as a law enforcement officer and not an independent reviewer. And for that reason, I terminated the telephonic interview, and then because I was upset, and I immediately, the same day, requested an in-person interview, of which he emailed me and indicated I would be contacted and interviewed in person after he reviewed the video, of which he never did.
Okay.
Mr. Chair,
Commissioner Shine.
I'd like to move that we accept for review the email chain at this time.
Okay. Is there a second? Is there discussion? Okay. On. Commissioner Foster? All in favor, please raise your right hand. Okay, all opposed? Commissioner Foster is opposed.
Mr. Chair,
Commissioner
and I
Shine?
now move to take my prior motion off the table.
Yes, you may. And remind me how we do that?
Just as a little second.
A second, okay. Is there a second to the motion to take the? A second. Okay. Any discussion about taking it off the table? Then, all in favor of taking it off the table, please raise your right hand. Okay, there's unanimous. Now, as to the body of the motion, can you remind us of the motion?
That's a tough question. No, I had moved that the matter be continued till next month, until such time. In the meantime, the IRO would interlineate or somehow mark on the transcript those portions of the transcript she thought were not accurate or some way did not reflect accurately the video, what was said on the video. And I'd like to add to the motion at this point that she also provide us next month with a transcript of the interview of Mr. Hernandez by the IRO investigator. So we can have that at the same time, since that's apparently an issue.
Is that something your office can provide us?
Yes, but I would submit that I would, prior to next month's meeting, submit materials that are in the record to the commission, which would be appropriate, would be a copy of, we can mail a copy of this DVD of the lapel stop, the camera, of which the issues are there, and the, also the phone interview by the investigator from our office. And so that the commission would have the leisure of their time and their own headphones and their own computer to hear what they need to hear. So perhaps the necessity of a transcript would be not necessary
I
then.
assume the interview is obviously audible. It's just a phone interview?
It's a phone interview, it's about
I'll
13
withdraw
minutes,
the transcript then, just as long as we get the original, not the original copy.
a copy. But I would provide that prior to the next meeting by mail to each commissioner.
Okay, so, Commissioner Siegel?
I seconded the motion, and I will accept the amendments as Commissioner Shine has.
Oh, there's no amendment. Well, there's restated. Let me restate the motion.
Please.
The only thing I'm moving is that the matter be continued until next month, in the interim, that the IRO interlineate some way those parts of the transcript she objects to, transcripts that she objects to, and so we'd have that when we review the transcripts next month.
And we will have the email chain, and we will also have a recording of the telephone interview.
I don't think we need to, I don't know if we need to make it part of the motion, but she's indicated she'd do that, so. And the lapel camera.
And the
video,
lapel
she's
camera
gonna say.
video.
And Mr. Chair, I'm sorry, could I interrupt?
Sure.
It's a complex thing. There is one additional exhibit that I would like to submit that is not part of the record, and so I didn't know if this would be an appropriate time to discuss that matter as well. And I provided a copy of that document to Mr. Hernandez earlier. And that would be, there's a printout from the Metropolitan Court computer system that notes from the judge why the case against Mr. Hernandez was dismissed. And so I believe Mr. Hernandez his appeal is based on that the officer was inaccurate in his report and somehow wants to argue that the court, because the court case was dismissed,
I
that
can make my
somehow,
own arguments, thank you.
somehow we'd like to tie that into the Metropolitan case that is no longer pending against Mr. Hernandez for, which is part of the record, that he was charged with excessive speed, open container, I believe another charge, and those were dismissed. And so I would like to submit the Metro Court record of the reason for that dismissal.
Okay, Commissioner Morella.
And are you talking about just the printout that's available on their website?
It's a printout that you get by going to the, if you have access to the Metro Courts, not the public website, but public defenders and district attorneys have access to the Metro Court database, and this is from the clerk at the database.
So it's a database and not the order itself?
It's not the order, it's a printout of what the order said, yeah.
Okay, let's go back and do the motion that's on the table,
I think,
and then we'll,
may I amend the motion to accept to add the provision that we would just accept the IRO's exhibit for review as well next month.
okay.
And I would object, and if I may.
You may state your reasons.
She did provide a copy of this exhibit. However, as is typical of this IRO, she only provides partial evidence, if you will. This case has been dismissed twice. It has been filed twice in court and dismissed twice in court. And of course, the record that she's trying to get in right now only provides for one of those dismissals and not both. So again, she's trying to influence the commission, and she's anything but independent. and that's all there is to it.
Yes, Chair Shine.
And additionally, if I may, I
No,
would
you
like
may
to.
not. You may stop.
Mr. Chair, I think the argument that I would still pursue my motion. If Mr. Hernandez believes there's more of a record that should be presented to us to complete the record, then he can do, he's welcome to do that next month when we resume the proceeding. But I still think it's legitimate for us to proceed with this motion.
Let me ask Ms. Hammer,
Yes,
could you get a copy of the other dismissal as
I
well?
can get a copy of the entire court file. It's just unclear whether, an order of dismissal sometimes just says dismissal. The internal documents within the database of the Metropolitan Court states the reason for dismissal. And so I would get the entire court file along with the printout from their database, which states the reason for dismissal, because those notes are taken, entered into the database contemporaneous with the event as it occurs by the court clerk, working inside the courtroom at the time. And so I can give the entire record and then some.
So, Mr. Chair,
Yeah.
may I then re-amend my motion to delete the matter of this particular exhibit on the assumption that next month Ms. Hammer will bring the original court file, and then there's no argument about what is what. And so all this motion is now is to continue the matter with the amendments to the two transcripts we were talking about.
Okay. Is that,
That's fine.
everybody okay with that? All right. Commissioner Siegel.
Thank you. As to IRO Hemmer's suggestion that these court files be brought in, I'm a little confused, I suppose, as to our role. I thought we were here to review a traffic stop and the attendant issues around that, and not the resolution of that in court much later. If that court case had come back with him guilty on 19 counts, or not guilty on X number of counts, and how many times it went through court, doesn't strike me as part of our business here today. I may be confused, and I'm happy to understand it in a different way.
Mr. Chair.
Commissioner Shine.
I would suggest that the issue of whether it should be admitted in evidence or not and be considered by us is for next month. We don't have to decide that now. All we're saying is bring it, so we have the option. So we'll decide next month.
Okay, and you may vote against the motion if you choose. All right. So, any other discussion? All in favor of the motion, please raise your right hand. It is unanimous. And other than what we've spoken about, there will be no other evidence. We're going to do this next month.
Thank you.
Okay. Our next citizen appeal is CPC 256-12.
And perhaps the appellant is here, perhaps you could read the rules again.
Yes. Okay. For the appeal, our rules indicate that you will have, I'm sorry, I don't have your name in front of me.
My name is Jason Delavisa.
Mr. Delavisa, thank you for being here. You will have 15 minutes to state your appeal. There will be 5 minutes for the police officer involved if that officer is present. There will be 10 minutes for the Albuquerque Police Department, 10 minutes for the independent review officer, and then 5 minutes for you to make a rebuttal. So when you're ready.
I'm sorry to interrupt, Mr. Chair.
Yes.
Mr. Delavisa provided a partial transcript of the lapel camera video interviews in his case as well, and I do have concerns about those as well, and so if we could have the same evidence discussion with Mr. Delavisa, what his intentions were. I don't know if he intends to introduce them or
Okay.
exactly where we are.
So can you tell us about that?
Yeah, I'd like to start by saying I wasn't notified about this hearing until yesterday afternoon. I received a telephone call from somebody in Ms. Hammer's office informing me that they were gonna send some information to me both by email and by regular mail, and they did. And it is this packet that I received. And also it included the lapel video from the police officer, but this disc is blank. So there's nothing on it. And so I had to send my staff, my office staff down to the evidence department to obtain my own copy of the lapel camera video, and I haven't had any time to do anything with it.
So would you like to postpone your appeal?
I believe so, and my other concern is that I had asked them to interview another staff member during their investigation, and they did not.
I'm not sure that's going to be possible at this
Okay.
point. Is there a 90-day rule here?
There is a 90-day rule here. Should I address things in order? Or?
Yes, you may.
With respect to the notice to Mr. De Luisa, we mailed him a certified letter. My assistant, Ms. Garcia, did on December the 18th. By certified mail, we received a receipt back that it was delivered to his business on December the 19th. And so as far as beyond that, I don't know how he did not receive notice, but we did mail him a letter which was delivered, and we have the receipt from the post office. And we did provide him with the packet that we provided the commission for as far as the record. And the first that I heard that the tape was blank was this morning. Staff did make a a CD, and staff checked it and said there were 3 files on the CD, and that one of them, they played. But I haven't looked at the copy that he has with him to say I can just report what staff reported.
Right.
But with respect to the continuing, I think that the question would be, is it whether or not he wants to submit a transcript of the interviews, and if so, then they would be of all of the interview, the entirety of the investigation. Mr. De Luisa submitted portions of some of the people who were interviewed in his case. And so that would be the question if there's completeness.
So you're submitting there should be a full transcript,
I don't have an objection to that, if that's what.
but you do have an objection to a partial transcript.
Yes.
I see.
Mr. Chair,
Commissioner Shine?
may I move to continue this matter until next month with the request to the IRO that she have prepared by some independent person, whoever that should be, transcripts of all of the videos in this case. I've listened to these videos, and some of them are very difficult to hear, but there are, if you listen closely and spend some time, you can do an accurate transcript of these videos. And so I think it would be helpful to the commission to have the transcripts of the videos.
My question is whose responsibility are the transcripts?
Well, that would be ours.
Okay. Would your office be able to do that?
I believe so. How quickly is the question? I would certainly offer the same thing that I offered in the other case, that I will mail a copy of the lapel interviews. This officer did record his interviews with the individuals involved. You already have a copy of the police report in this case, and a copy of the complaint. So I think that you can listen to the tape yourself and leisure of your home if you're interested.
So we would not need transcripts then?
No, I think my own, if I may respond, Mr. Chair.
Sure.
Having listened to the videos, they're very difficult to hear, and a transcript, one of the purposes of transcripts is to assist the listener in understanding what's on the transcript. So I think it would be useful to still ask the IRO to prepare the transcripts, or have the transcripts prepared of the videos, so we can each have the transcripts when we review the videos.
I can say that, but I can tell you professional transcribers inaudible is what they put when they can't hear what's going on. And so if you can't hear it, you can't hear it. They don't make it up. So I don't know if that's the reason for the transcripts. I don't know.
When I say it's, I'm not suggesting it's inaudible. I'm suggesting it's difficult to hear. In the third interview, the woman is sitting a bit across the room, so that it's not as loud as it otherwise would be. So with adjusting a volume, it can be transcribed.
I would suggest, I mean, my own personal opinion is that it's an unfair burden on the IRO's office to prepare a transcript when we could have video, when we could have the recording, and judge for ourselves. I mean, I think I'm willing to take the risk and I'll be able to hear it, even if it's difficult to hear, if it's hearable. Commissioner Siegel.
Thank you. A few minutes ago, we heard the appellant say that he had made transcriptions somehow or another. My question first is whether you made these yourself by listening to these tapes, or whether you had a third party transcribe them.
I gave them to the secretary in our office who often transcribes medical records, given the amount of time that I had to do this.
And did you listen to them as well and amend those, or offer extra wording where that person may have found it inaudible? Did you help the transcription?
Yes.
Okay, thank you for your candor. It still seems to me that it might be useful that you submit those to the IRO for her review, and then she could comment to us that these parts are true, or they're, in her opinion, inaudible, and then we could make, and again, she could mark the parts that she finds inaudible, and we could make our own minds up, turning up the volume, as Commissioner Shine suggested, or otherwise, and we'll at least understand those portions.
But I think the objection Ms. Hammer had was that it was a partial transcript and not the full transcript.
That's
So
true.
she was suggesting that we just have the recording so that we could have the full transcript.
From my point of view, I would take what I could get, certainly with the caveat that there are underlines, asterisks, or brackets around questionable transcription parts.
My,
Point of order, Mr. Chair, I do believe there is a motion, unless I'm wrong, I think there's a motion pending, and the motion calls for the preparation of the transcripts. So
Okay,
people-
all right,
People can vote on that.
all right,
May I say one thing?
yes.
When I spoke to Ms. Hammer on the phone yesterday, she told me she felt the officer did not say something that I feel like he did say. So I do feel like because the transcript, or the video can be difficult to hear, it might be useful to have the transcripts, both for her and for myself.
And one of the things that, one of the values of asking the IRO to take care of preparing the transcripts is it's a quote, independent preparation of the transcript, so there's no argument that there's a biased transcript or anything like that. So, in my conversations with Ms. Hammer, she indicated that she would be able to do that. So I'm not
well,
sure.
we can do it. It costs money, and where do you want to spend your money? The money we spend on that is money we don't spend on travel, et cetera, et cetera. So, the other alternative would be, Mr. Delalusa has his transcription, has done part of it. If she wants to prepare the whole thing, then we could, he and I could discuss it over the phone and, delineate it out.
My motion doesn't necessarily require you or anybody else, but just something that you take care of preparing. I don't care how you get it prepared. If you can get the transcriptionist to do it and you're satisfied with it, that's fine with me.
I think that Mr. Delalusa,
Tell Louisa.
Mr. Delalusa and I could work it out. Would you think that's great?
Okay,
I think so.
with that caveat, then the motion is that we continue this and expect to have a full transcript of the interviews.
Not the interviews, the videos.
Of the videos, the lapel videos. Mr. Foster?
What's the video? The transcript plus the video?
Yeah.
Well, I would submit that I'll give you the videos now, or close to now, and you have all month. You will have the transcripts at the hearing, because they're new evidence which needs to be moved and admitted by the commission. And if Mr. DeLuise and I can't work it out, then that'll be something to be resolved next month.
Mr. Chair, may I?
Wait, Commissioner Peterson?
I think Ms. Hammer just answered my question, but I'm curious about the videos. Is that something we can get
Mhm.
pretty quickly?
Yeah, we
In
can get
both
voted on
cases?
both cases, we can get them, I'll put them in the US mail tomorrow.
Perfect, thank you.
Commissioner Shaw?
Mr. Chair, may I just suggest that we would still have to, if Ms. Hammer and the appellant can agree that the transcripts are accurate before the hearing, it would be helpful, I think, if she distributed those in advance to us, so that we would, when we're reviewing it in advance, we have the benefit of the transcripts. I don't know that we have to formally have them in evidence for us to see the transcripts, just as we've agreed here that if both sides agree, the document could be presented to us, so before we decide on whether to admit it into the record. All I'm saying is if you stipulate with the appellant that the transcripts are accurate, you can send them to us in advance, and then we can decide later whether they're going to be in evidence in the record.
Is that reasonable?
If we can stipulate, we will, and if we won't, we won't. How's that?
Okay. All right. We didn't have a second. Commissioner Varela will second the motion. All in favor, please raise your right hand. All opposed? Commissioner Foster is opposed. All right, we'll see you next month, Mr. DeLuisa.
Thank you for your time.
You're welcome.
The second Thursday of next month.
Okay, we move on to citizen appeals. I mean, not appeals, CPCs, complaints, citizen complaints.
Thank you. There are three, first an explanation. Between POC meetings, there are really 3 weeks in which to work, because I send out the materials a week ahead of time. And because of the way the dates fell and the society in America, many people take off between Christmas and New Year's. And then this week, the school holiday was 2 full weeks. And so there were many individuals who were working at the Albuquerque Police Department who were off in the chain of command. And so because of the holiday, there are 3, you're all familiar with my process of I write my letters, I send them to the police department. The police department has 3 separate individuals who review each and every letter, and then that comes back to me. And if people are gone, one person in that link of that chain, then my letter sits on someone's desk somewhere across the city. So there are 3 fully investigated cases for us this month, and then the remainder are inactivations. And so I would like to move the inactivations as a consent agenda at this time, unless there are objections.
Is there a motion that we receive these inactivated CPCs as a consent agenda?
Mr. Chair,
Yes.
can I ask that we have the ILO list the numbers of the CPCs we're talking about that's going to be subject to this motion?
Sure. The first one is 6 separate cases filed by one individual dealt with in one letter, and that's CPC 152-13, 166-13, 222-13, 225-13, 226-13, and 230-13. That's one letter based on 6 separate complaints by the same individual, alleging basically the same thing. The next inactivation is 188-13. The next is CPC 213-13. The next is CPC 220-13. The next is 235-13. The next is 237-13. 239-13. 240-13. 241-13, and 244-13. Those are the inactivations for this month.
I'm sorry, I can't keep up with these and then review and put my notes on them and then check to see whether they should be inactivated. I'd ask you to, after the first cluster one,
Right.
to
There's
reread
only
them
one.
slowly, and then I can flip through my
Do you
cases
have-
and see if I have any issues.
Okay.
Thank you.
Would it be easier to say that the names of the 3 full cases and then everything else you would know? The 3 full cases are the first 2 on the first line, 139-12 and 189-12. The third full case is 174-13. Everything else is an inactivation.
Could you give us just a moment to look these over?
Sure.
Thank you, Mr. Chairman. Mr. Chairman?
Yes, Commissioner Siegel.
Thank you. Upon review, I would request that 188-13 be pulled from the consent agenda and reviewed more thoroughly. Thank you.
Okay,
Mr. Chair,
Commissioner Shine.
I would ask that we pull 213.3 and 235.13.
Okay. Yes, Commissioner Foster.
Commissioner Siegel? Commissioner
No,
Shine?
do not address me.
Okay, Mr. Chairman?
Yes.
I are looking as well. It's in,
They have that right. It is their right to take anything off the consent agenda. So Commissioner Siegel asked for 188, Commissioner Shine asked for 213 and 235, is that correct? Correct. Okay, so do I hear a motion that we accept the consent agenda for all the other inactivations?
Also move.
Is there a second? Commissioner Burrows, seconds. All in favor, please raise your right hand. Okay, it is unanimous.
Thank you. The first case I'd like to present is CPC 139-12. And this involves an incident of a domestic violence call in which the complainant complained that the officers used force against herself and her son, that they failed to accurately report what went on. Full investigation was conducted, and review of the lapel cameras of the officer, of a belt tape recording by an officer who didn't have a lapel but had an audio recording going, as well as photographs taken. And I made a determination that the amount of force that was used by Officer C was appropriate and exonerated Officer C conduct with respect to that allegation. There was an allegation that the officers did not treat her son by medical care, when in fact rescue was called. He was treated at the scene and he was later taken to the hospital from the substation. And so I found that that was unfounded. And with respect to the allegation that the report was not accurate, after review of the lapel camera, I determined that the police report was accurate and that that allegation was unfounded, which means was false or not based on valid facts. I reviewed the same allegations against Officer S, and made the same findings. I ask you to adopt the letter as written.
I move approval of CPC 139-12. Is there a second? Commissioner Barker, is there discussion?
Mr. Chair.
Commissioner Shine.
Mr. Chair, I'm going to vote no on this letter, and the reason I'm going to vote no is because I can't make an independent judgment because I haven't been able to review the videos in this case. And the reason I haven't been able to review the videos in the case is because the provision in the union contract and the resulting cease and desist letter the IRO brought to our attention last month. So in my judgment, the union contract provision inappropriately limits the Commission's ability to review the evidence, and in this case, I can't decide whether the amount of force is reasonable unless I see the video. So therefore, I'm voting no.
Okay. Is there other discussion? All in Okay, let's vote. Mr. Siegel.
Thank you. At several points in this write-up, I'm becoming confused trying to understand which officer the allegation is being reviewed against and the statements. For example, at page you know what, I'm going to withdraw this and not make a comment. I'm following it better upon third reading. Thank you.
Okay. Any other discussion? All in favor of accepting CPC 139-12, please raise your right hand. All opposed? Okay, Commissioner Barella and Shine opposed. It passes.
The next case is CPC 189-12. This is a case in which an individual is complaining that he was not arrested, but yet officers still took DNA evidence from a private part of his body without a warrant. A review of the evidence shows that the individual was under arrest at the time. He'd been given his Miranda warnings, and while I don't believe he was actually inside of a jail cell at this time, he was in custody at the time that the evidence was collected. I found that this individual has also filed a similar motion in his criminal case, which is still pending. That motion will be heard, the criminal case motion will be heard in February this year, at least that's what it's scheduled for. And based on my review, I found that the officers followed the SOP with respect to exigent circumstances in obtaining evidence, and found that the allegations against the detective who interviewed the individual as well and was the case agent, as well as the officer who conducted the search, that the charges against them should be, the allegations against them should be exonerated. There was a second type of allegation that the officer was rude and unprofessional at the time of the collection. I reviewed the video and did not see that that officer made any snide remarks that were alleged by the complainant, and found that officers should be exonerated for as far as being unprofessional. I asked to adopt the letter as written. I ask that you adopt this letter as written.
I move adoption of 189-12. Is there a second?
Second.
Commissioner Foster seconds. Is there discussion? Commissioner Barella.
Cannot vote for this letter, basically because of the part where there's exigent circumstances. I believe because the citizen was in custody and that he was in custody of the police department, they could have kept him in custody and obtained a warrant from a judge without the high probability that the evidence would be lost at that time. So that's my issue with this particular letter. I think that the actual fact that he was arrested and in custody goes to them being able to monitor him and be there with the police force while they went in front of a judge to obtain a warrant for the search.
Okay. Is there other discussion? Commissioner Siegel.
Thank you, Mr. Chairman. I had several of the same concerns and took the trouble to look up the SOPs cited by Ms. Hemmer. SOP 2-12, which appears at the bottom of page 2, is titled Interviews and Collection of Evidence at Hospitals. Was this collection done at a hospital?
I believe that it was a medical area, yes, of the jail, which is considered, I believe, fitting under that SOP. That's how the department has interpreted medical place areas.
Okay, and then under that same SOP, it talks about body cavity swabbings and evidence retained in the body. And in both cases, it says when permission is denied, a search warrant or court order will be obtained, unless the subject voluntarily says he can have it. So I have real concerns that even in spite of the appellation of the jail area being called a hospital in this case, that it doesn't seem that the complainant felt that he had granted that right. And then likewise, it's under 217.16, it says that search incident to a lawful arrest can be conducted. It must be conducted during or very near to the time and place of arrest, and must be limited in scope. And I guess my best understanding of that SOP as well is it points toward requiring a warrant from a judge to obtain this evidence if the person doesn't consent. So with that, I have my concerns about this case. I would listen to your comments back to me on my understandings.
Well, the exigent circumstances would be that because the evidence being sought is, there are types of swabs of a male's penis that are for gathering standards as well as gathering evidence. And so it was the belief by this detective that the evidence could be lost, not because he would flush it down, well, I guess he would, but could be lost not because the physical piece of evidence would be destroyed, but that the DNA would be lost through natural urination process of the individual. And that they wanted to get the swab immediately, and that was her exigent circumstances. I say that it's my position that she had, that there's 51% or not, that she followed the SOP with respect to exigent circumstances, and that there are the SOPs with respect to searches, but there are exceptions to those SOPs for exigent circumstances. And in this case, at this time, this officer believes she did. And that it is my strong belief that the appropriate remedy for Mr. Willis is to do as he and his attorney are doing, fight this matter in district court in his criminal case, so that this officer follow the SOP with respect to the rules, and that if a court of law could find one way, a court of appeals could find another way, and the Supreme Court could find a third way. But our job is to look at whether or not this officer followed the rules that she had in place at the time.
Yes, Mr. Shine.
Could I ask, I don't mean to be getting too graphic here, but are we talking when this swab is taken, is it the swab of the urethra?
Yes,
Oh, it's not the external part of the organ, it's the urethra?
yes.
Thank you.
Any others? You ready to vote? All in favor of approving the IRO's letter for CPC 189-12, please raise your right hand. Okay, all opposed? Commissioners Siegel and Barella are opposed.
The next case is
Sorry, that last one passed.
Thank you. The next case is 174-13. This is a case in which an individual was first entered into Metro Court and then left Metro Court and then attempted to enter through an exit door and not be screened again, as there is screening for Metro Court, like many courts, with security, including Albuquerque Police Department, scanners, x-ray machines, and metal detectors. And the complainant did not want to do that for whatever reason. So that drew the attention of the complainant to an Albuquerque Police Department officer who was working along with other private security at the Metropolitan Court. Then they had a discussion with each other about why that was important. That was the complaint, that the individual alleged that the Albuquerque Police Department personnel spoke with him and confronted him because of his ethnicity, and that their reasons were bias-based policing. As well as the complaint was that they acted unprofessionally and didn't use a lapel camera, as my complaint. So, I reviewed the investigation in this case. In this case, the complainant was attempted to be contacted by phone messages and a certified letter, but no response. So the investigation was based upon his written complaints, and an interview of the officers involved was done. I determined that based on the interview of the officers, all of the individuals, that there was a legitimate reason for the officers to contact the individual, and that their motive was not racially based. So I found that allegation to be unfounded. With respect to them conducting them professionally, I found that there was no lapel camera of the incident, and even though more than one officer said, even an uninvolved officer said that the individual complained about was professional, I found that allegation to be not sustained, meaning that there was insufficient evidence to prove or disprove the allegation. With respect to the requirement that this case be lapel cameraed, I found that the officer did not record the incident as required, and that he should be sustained on that. The Albuquerque Police Department chain of command agreed with my findings. The chief of police imposed a verbal reprimand as discipline in this case for the failure to record. I ask you to adopt the letter as written.
I move approval of CPC 174-13. Is there a second? Mr. Barker seconds. Is there discussion? Commissioner Peterson.
Ms. Emmer, I have two questions, and the first one you may or may not be able to answer. It's saying that there's no surveillance video available to review from the Metropolitan Court because they only keep their video for a short period of time. The complaint was 2 days old on this one. Is a short period of time, did they keep their tapes 1 day? Do you know?
I don't know how long the short period of time is, but even if the complaint came into our office, it would have been assigned to an investigator in our time.
I just didn't know.
When they asked for it, I could pull the file and look, but I don't know that off the top of my head.
And then I guess the second question I had, it says Officer L believed that the complainant did assault him because he got within inches of him. Is that the definition of assault? If I encroach within in your space, is that assault?
If your actions are such, it's a fear of immediate battery or harm, and so that can be by actions or words. So I could be across the room and I could say, I'm going to come hit you, and if my demeanor is such that it's credible, then that would be an assault on my part.
Thank you.
Okay, any other discussion? Commissioner Siegel.
Absolutely trivial cleanup on page 2, second paragraph. The second letter in the complainant's name is shown there as A, whereas all throughout the rest of the case it's I. Just if you wouldn't mind cleaning that up. Thank you.
Okay, let's go ahead and vote. All in favor of approval of CPC 174-13, please raise your right hand. It is unanimous.
The next case has to be reviewed is 188-13. This is a case in which an individual alleged that there was an improper stop, and that someone was, that they searched her car without providing any explanation. This case was assigned to the Internal Affairs Division to investigate. The Internal Affairs investigator could not contact the individual. They would not return phone calls, emails, or a certified letter. The investigator attempted to determine from APD's communication center if any APD employee had encountered this individual, the person who complained, and determined that there was no record of any APD officer conducting any sort of interaction with this individual. In addition, in an effort to see if another agency had, often when the police contact an individual, they call out to run a records check on an individual, and there's a way to track whether or not any other agency ran a records check on this complainant. And no agency within a 3-day period of when she said that the incident occurred had checked records against this individual. So there was no way to prove, one, that APD was involved. I believe we can prove that APD was not involved with respect to any official police activity. And there was no other agency had as well. And without her cooperation, there was no way to further the investigation because all avenues were closed. And so I'm asking to inactivate this case because we cannot prove that it's APD, and if it's not APD, we have no jurisdiction.
Okay, I'll move approval of CPC 188-13. Is there a second? Second. Mr. Peterson. Is there discussion? Mr. Siegel.
Thank you. I ask that this be pulled for this reason. The allegation is serious from the complainant, that two officers improperly searched the complainant's car without providing any explanation. If that had occurred, and it's just an allegation, it strikes me it would be a fairly serious infraction. Therefore, it seems to me that an inactivation is not the correct way to move away from the case, but rather to find either not sustained or unfounded. I do recognize that there is no officer involved and no individual will receive reprimand under any circumstances or even have a mark against his or her record. But I think that on a case like this, where it is not a minor allegation, it is a serious allegation, and therefore inactivation is not appropriate, but a not sustained or an unfounded IRO's option would be appropriate.
I'm sorry, go ahead.
May I just answer that real quick?
Yes.
Because we can't prove it's APD, I can't unfound anything against APD. If we had been able to prove that somehow APD was involved, this would have been a full investigation without the woman's cooperation or not. It wouldn't have mattered. But we had, the investigator did his best efforts under all the manners in which we could to find a human being to hold accountable, and we have no way to go. There's no evidence that APD was involved. And we certainly, this would have been a full investigation, even if she hadn't, despite her non-cooperation, if we had had some evidence that APD was involved.
I fully understand your comment. My own crib notes say that unfounded means that the allegation is false or not based on valid facts. So unfounded seems a reasonable finding, and it's a lot different to me than a simple inactivation.
Okay, is there any other discussion? Commissioner
I
Shine.
would just underline this, the IRO's point. I mean, it's got to be unfounded against somebody. It's not in the ether. So you've got to identify a person, and it's got to be an APD person to be meaningfully unfounded. So I'm going to vote in favor of this.
All right. All in favor of approving CPC 188-13, please raise your right hand. All opposed? Mr. Siegel is opposed. It's passed.
The next case is CPC 213-13. This is an incident in which she was driving home, and the allegation was that she was alone in an unsafe neighborhood after work. That she gave her 2 citations, and she was confused about the rolling stop versus the failure to stop. And this case was assigned to an investigator in my office who discussed the matter with the complainant. They reviewed the lapel video as well and determined that the traffic stop was appropriate length and time. She didn't allege that there was any SOP violations because even if the facts were true, there would be no violations. Having a too long of a traffic stop is not a violation in and of itself. So I move to inactivate on this case because there is no allegation of an SOP.
I move approval of CPC 213-13. Is there a second? Commissioner Barker?
The officers, both of them, followed the SOP with respect to the use of force and with respect to and therefore their actions should be exonerated, and that both officers, one officer should be exonerated on the SOP for lapel because she followed the procedure when the camera wasn't working, noted it prior to the call, and noted it in her report, And then the second officer would be non-sustained, as we couldn't prove that he hadn't complied with the SOP, and he partially complied with it. So I want to show you the photos and give you the caveat. It's my understanding that these photos aren't shown on television, that are just our descriptions of them are, and that they do include photos of the injured person as well as the dog. This is the individual, Mr. P, as he was seen at the hospital. You can see that there are dog bites on his nose, right here.
We're not seeing this.
It's over there.
It's
You
not-
see it over there, it's not on our TV.
I don't know what to say.
Apparently the TV's not working.
Can you see over here?
Not well, no. Here we go.
You'll see that his nose was bit several places. His eyebrows were bit. They're severe and deep wounds. His head was bit. His arm was bit. Several places. Up here in the armpit area, there's a large laceration from the dog bite up in there. His legs were bit as well. And these photographs were at the hospital, so at the time when the officers were there, there was even more blood than what's here. This is an overall of the street. Oops, and I forgot to mention this part in the story. The individuals, when they were walking, they were just walking down the street. And these dogs came out of the sides of the street from nowhere, basically, and attacked them. These two individuals, Mr. S and Mr. P, they hadn't seen each other in a while, talking, and these dogs attacked them. And so they try to get away from the dogs. So they run on top of this first car here, which is a small type car. And they get on top of the roof of that car, and the large dogs jumped on top of the roof of the car and continued to attack them on the top of the roof of this small car. And you can see that when they jumped on the roof of the car, they broke out the front windshield of the car, and it's hard to see from a distance, but there's blood splatter here. So by the time they even jumped on this car, Mr. P had already been injured by the dog. And there's the large pools of blood coming off the back of the first car as Mr. P is running away or trying to decide that they're going to further run down the street. This is the Lincoln Navigator that they jumped on. You can kind of see the dust on the front of the car where they scramble up the hood to get on the roof of this car, of this vehicle, and that's where they were when the police arrived. This is Officer L's car, and there's a cone marking where the dog approximately was when the first shots were fired. There's the animal control vehicle with the door open, and that's the door that the female dog ran into that was later shot, and then she was later secured. You can also see in this photo, these are the casings in the street. And this cone here is in an attempt to locate the approximate location where Officer L, behind her vehicle, shot at the dog. This shows the dog where after they moved it by animal control, that's not where it was first shot. And this is the photograph of the dog. And this was the companion of the individual who was injured, the blood that was from his companion as he was trying to save. So I'd ask you, Sergeant Liz Thompson of the Albuquerque Police Department Homicide Unit is here if you have any questions. She's reviewed all the evidence as well. but I ask you to adopt the letter as written.
Ms. Hammer, if you could, tell me again why on the officer who did not call in about the video recorder problem, why you did not sustain that instead of sustaining it?
Because he partially complied with it, so I put it as a not sustained.
And how do we know that he partially complied?
Because we have, there is video of after the shootings occurred, they found out who the dog owner was. They also went to speak with the guy who owns the car that got the windshield
I see.
to explain what happened. We have videos of all of that going on. And we have the video of when he, gets back after chasing the second dog. That's when the camera goes on.
Okay. Commissioner Shine.
I'm also concerned about that issue. We've here had any number of cases in which the officer said, I tried to turn it on, or malfunctioned, or whatever, and we've sustained a violation of this SOP. I'm still not quite sure what distinguishes this from those many earlier situations we've looked at.
Because it was a review of the officer's camera that in fact there was a problem with the switch. But because he was, at the time, this was 2012 when cameras were first given out, it was a defective camera as far as the switch was difficult to turn on. And my belief, it wasn't appropriate to sustain this officer for something that wasn't his fault, because we could prove it that the camera didn't work.
So on those other situations where the camera didn't work and the officer said there was an attempt to look at the camera and the cameras were working fine.
Right, or we couldn't prove one way or the other.
I understand. I didn't understand that distinction. Thank you.
Commissioner Foster.
So IRO, you're saying that according to the SOP, if an officer sees that there is a problem with their equipment, are they not supposed to report that problem to their immediate supervisor, that there is a problem with that equipment?
Yes, he did. The one woman, when she found it out, she called out, and it's in the newer materials in the CAD report, she calls it out. But in the second officer, he puts it in his report as required, but he didn't call it out the second he did, because in the middle of shooting and chasing a dog.
But you said earlier that upon further investigation, there seemed to be a mechanical problem with this camera?
The switch.
Prior to this incident?
After this incident, they looked at his camera, found that the switch was faulty.
So I'm assuming that the camera worked prior to this incident?
I don't know where it was in his shift on that day. I didn't look at that.
Thank you.
Commissioner Barker.
Nowhere in the report does it say that the switch was faulty. It states that looked down and realized it wasn't working and pushed the button again, and then it worked. Imagine, we have two officers here, and one of them, the camera didn't work, and the other one, the supervisor, did not have time to provide a recording device.
The camera did work subsequent to it, the shooting. Subsequent to the incident slowing down, the officer turned it on and with greater force could turn it on. So it did work for a portion of the time.
Yes, and that's my point, is it didn't work during the action part, it worked later, and we're blaming the switch for that as opposed to operator error. And then, of course, my concern is that the officer, the supervisor, didn't have time to provide a recording device. We have two officers there, neither one of them was working. 0 for 2. That doesn't make sense to me.
Well, I can just report what the facts are. I don't take a judgment on the facts. I can say that the officer had what Sergeant Drager explained to you during the presentation about lapel cameras. Some of the cameras are expensive now and are well functioning, and some of them are were relatively inexpensive and not functioning well. And in the camera that this officer had at that time, both of them were of the inexpensive type at a time when no other department or a few other departments in the nation were even recording things. It was a sort of a prototype by the Albuquerque Police Department, an experiment to see how they were working. And obviously these cameras didn't work well. And I was told by the chief this week that within a few months, all officers will have the expensive $1,000 cameras.
Okay, Commissioner Barker?
I don't have a problem with that, and of course, in this case, the officer's actions. I guess what concerns me more is that the supervisor didn't have time to issue. So,
Well, I think it was, she called it out pretty much immediately after being dispatched. I'm dispatched to a call and, oh, by the way, my camera doesn't work. So it wasn't as though he said, I can't come. There physically wasn't time for it to occur.
Commissioner Foster?
IRO, I really have a problem with the camera issue. The shooting I have no problem with, but I do have a problem with the, so can you explain to me, was there a different SOP at this time? Or is the current SOP in relation to cameras, was that the one that we are looking at this point in time?
I believe the SOP changes in 2012, July is when I believe it changes, and what that part of it changed is about that every contact needs to be recorded, and that they say for 120 days versus 90 days. I believe that was the change that occurred in 2012, July.
This occurred on June 14th, 2012.
But I believe that the relevant parts about the officer calling out as she did, that part is still there and was there at the time.
That is new information that I don't remember seeing in any of the reports about the camera being identified as faulty after the incident.
Right. I spoke with the officer's chain of command, and that's what I was informed. He did write in his report, though, about that the switch wasn't working, and he looks down and pushes it after the incident. It's over with when he's doing the interviews, and it was working. But that is his belief that it was the machine itself as opposed to operator error.
Well, in order to be able to get discussion going, I would move acceptance of I-112-12. Is there a second?
Second it.
Commissioner Peterson seconds. With that information about it being checked, I personally am willing to support this letter, recognizing that it was in the infancy of the lapel video cameras, and it does seem that there was some compliance on the officer's part. Is there other discussion, Commissioner Shine?
I would concur with you, but I would ask that the letter be modified, because the letter does not make clear why that second officer was being not sustained. But the letter be modified to show that the camera on examination at the incident was found to be defective, physically defective, so we couldn't have complied.
Okay.
With that change, I would.
You can do that?
Yes.
Okay. Commissioner Peterson?
Thank you. I too have a little bit of issues with the camera aspect, but I noted in the report, and then I certainly have no objections to the case and how it played out. And I don't think there's any question that when it was all said and done, there was 5 shots fired. But I noted when I was reading through the officer's reports that Officer J made no mention of Officer L firing a shot. And I don't know if that's because Officer J arrived on the scene after Officer L had already fired. I would think that shots fired by any other officer would be fairly noteworthy.
You would think.
Yeah, I mean, because Officer L makes reference to Officer J firing, but not vice
Right.
versa.
I can say that the way that animals being shot And I can note in my time that I've never seen a cat shot, so I think fair to say to talk about dogs. The dogs being shot are not treated to the same level of investigation that other shooting at occupied vehicles or persons are treated. These are not, the evidence is gathered by someone who's not a sworn officer, even their civilian employees who do, they're called FETs, Field and Evidence Technicians. There would have been a sergeant out there, maybe a lieutenant, I'm not sure exactly, but it wasn't certainly Sergeant Thomas and her esteemed colleagues in the multi-jurisdictional shooting team, and the breadth of review that goes on for person shootings does not exist in dogs. And do I think that the officers involved, both of them, could have done a little better job in making the report? You betcha. Especially, there's no mention in Officer J report as well that he did interview the owner of the broken car, or the damaged car, and the owner of the dog, and what they found out. I do have concerns about that, and I've raised those with the chief about the lack of this individual report. Do I think it rises to the level in SOP violation? No, but I do think that there was room for improvement in that report.
Thank you.
Any other discussion? You ready to vote? All in favor of approving officer involved shooting letter I-112-12, please raise your right hand. It is unanimous. Okay, we move right along to the long-term planning committee report. Mr. Shine.
Thank you, Mr. Chair. I would report that there were two items on our agenda. One was referred back to the committee by the chair at the December meeting of the POC, and that is to explore the issue of the standards for inactivating POCs and the rule provision. There was some discussion, a proposal was made by the IRO. We had some discussion, changed some language, and there's now there was a proposed amendment to the Section 5 of Article 4 of the Commission's rules, and I will briefly review them and make a motion that we amend the rule as follows. And then after I make the motion, if it's seconded, I'll move to table it till next week so that we can give the proper notice for a rules change. And, table it not to next week, to next month, and so that it can be brought up as a rules amendment next month. We would amend Section 5, Article 4 of our rules by adding the word calendar after the numbers 90 in section B, subsection B1, by adding on B5 at the end of the sentence a comma and with the words either formally or informally on
The job well done for report for the month of December. Much like we do report out in the minutes all of the complaints that we addressed in any one particular month, there's the other side of it as well. Back in January of 2013, last year, I developed this program, the Job Well Done program, in which individuals could report about good things that they liked about the Albuquerque Police Department in general or in particular. And so every month we receive these reports. There was some sort of glitch. They're done, we receive them from the website. There's a parallel button off of the file a complaint. You can also file a compliment. And these compliments we've received over the year. In 2013, we received 166 compliments for police officers. And so I thought it was important for the commission as well as the public to have a brief understanding of the types of compliments that we get on a monthly basis from officers. In addition, there are cases in which officers, their supervisors are called directly, but I report on the ones that are sent through our website. And those are dealt with by forwarding to the chief of police, who sends a letter to the officer, and to and the matter is put in the officer's personnel file. And we do a little research. If they just say an officer and give us enough information, we find out who that person actually is so that that person can receive the compliment that was given to them by the public. And so you provided in your materials were the 16 job well dones that we received in the month of December. And in addition, in December, we received 21 complaints, the new complaints which were filed, and we'll be addressing. And as you know, we addressed 24 separate CPCs and resolved or closed them in some manner last month. And we're continuing to do our work here and trying to push out the backlog that we have that was created and to revise, yet re-revise the letters to conform with the cease and desist letter. So that's what we're doing at the moment, and so we're continuing on.
Are there questions for Ms. Hammer? Mr. Siegel?
I guess it occurs to me to ask, we've had a couple dog shoot cases in a couple of months with no shoot cases whatsoever. What is the backlog then of human shootings, and why are we not hearing one a month until that backlog is cleared?
We only missed 1 month, and that was December, in which we did not get a shooting letter out. We've done a shooting a month except for the month of December. Shooting cases are a complex matter, and I'm sorry I don't have the number before you, and I can provide that by email and we'll report it at the next meeting. But I try to deal with shooting cases. Obviously humans are more priority than dogs. But I review a shooting case, I meet with individuals that are involved in the investigation, I go over all of the evidence, sometimes which it's 10 inches thick of paper, depending on the case, but it's a lot of material. And once I make that determination, then I move forward and make my proposal to the chief. Sometimes I get in the middle of those 10 inches and determine that I have questions and ask for additional information. And the shooting that I had planned to present in December is such a case that I got into the middle of my review and determined that I personally had questions before I could make a professional opinion about the finding in that case. It's taken longer than I thought to get that question answered, and I continue to work on that on that one case. But in the meantime, I've picked up Plan B and moving forward with others, such we have the dog case in this one, and yet we'll have a case that I hadn't even planned on yet for next month as well, hopefully. But the complexity is the lead time as well. It takes me about a week of review to get through a shooting case. Then it takes time for the chain of command, like I said, to review it, and then to get it out. In 3 weeks from now, another letter is going to go out to you. And so today I just learned that this case I was going to do December, then planned to do in February is not going to go because of the additional information that I need is still not available. So that's kind of where I'm at. I continue to work on human shootings, and I will give you the number that we have that are not done, but I'm trying to get to the older ones before the newer ones.
Okay, thank you, Ms. Hammer. Oh, I'm sorry, Commissioner Shaw.
First, let me commend you on the Job Well Done program. I think it's very helpful, and it's very helpful to bring it to us and make it public and communicate it. And I would hope you could put it on the website as well, this kind of report, put it on the website as well so the public can see it. The only thing I was curious about is at one point about 2 months ago or 3 months ago, I sent a commendation forward for a sergeant, and I never heard back from anybody on it. And I don't know what your procedure is in terms of the job well done, but if I could make a suggestion, you may want to, for each of them, send some kind of communication back to the person who sends it in saying thank you and this is what we've done with it or not done with it or whatever. Give them some feedback.
Yeah, that sounds like a great idea. Thank you.
Thank you.
Okay, thank you. Investigator Scott Stapole, do you have anything for us from the SOP committee?
Mr. Chair and distinguished commissioners, I have nothing to report. There was no meetings, there's been no updates or anything like that, I'm assuming, because of the holiday season.
Okay, thank you. Mr. Lutz has abandoned us, but he gave fair warning. Any other city council staff? Okay. Then Mr. Du Bois, city attorney staff.
John Du Bois with City Legal, and I have nothing to report, but I'll stand for any questions.
Any questions for Mr. Du Bois? Hearing none, thank you very much.
Thank you.
Lieutenant Jordan, report from APD.
Mr. Chairman, Commissioners, and did you receive a copy this time? I know we said
Good.
good. As you can see, for the month of December, we received 38,842 calls for service. For internal cases received for the month of December were 22. We inactivated 1 internal case, 0 cases remediated. Total internal cases completed for December were 10. Internal sustained cases were also 10. Discipline was 2 verbal reprimands were issued, 4 letters of reprimands were issued, 2 8-hour suspensions were issued, 1 24-hour suspension was issued, and 1 120-hour suspension was issued. In pending cases, and it should say December, not November, that's a typo, at the bottom there are 18. And I'll stand for any questions if the commission has any for me.
Questions for Lieutenant Jordan? Yes, Commissioner Siegler.
Thank you. And this comes from one of the citizen complaint letters that we received this month. And we put it on the consent agenda. The citizen asked how many citizens are issued, how many citations are issued for tinted windows, and is there a different standard for officer patrol cars than there is for ordinary citizens? Explain at least maybe the second half of that. I imagine you have to look up the first part.
Correct. The number, and we're in the process, obviously, department-wide of preparing all our end-of-the-year reporting for numbers and statistics. When it comes to standards, there is a legal standard of tint under state statute, and that is the standard that we follow. Off the top of my head, I can't give you the percentages.
20%.
Thank you. And that's the standard the department follows and the city follows.
And as for me to fully understand, then the department follows the same standard that any ordinary citizen has to follow for how dark the tint is, for lack of a better word. Thank you.
Unless, as the IRO pointed out, UC cars will take some exceptions for certain, because as we discussed, I believe it was in last month's meeting, that sometimes we do have the ability for undercover operations if certain violations are appropriate for the operation. So for some of our UC cars, but I can't give you a number of how many we have of those.
No, I was asking, I think, about ordinary patrol cars, and I imagine the citizen wants to. Thank you so much.
Yes, Commissioner Shine.
Could I just ask, curious, you often see cars that are so darkly tinted you can't see inside the window. I thought that was not lawful. Is that, am I misunderstanding that?
Usually the way we
Civilian cars, I'm not talking about police cars.
We have a way we have tint meters. They're a device that some of our officers do have, where if there's a question about it, we apply this meter that gives us the percentage. Then we can determine if it's a violation. Do tinting shops in the city provide tint to the citizens that are in violation of law? Yes, it does happen. But we do have a way through using the tint meter to determine if the tint is not. We just don't visualize it.
Is the rough standard that you should be able to see into the car, to see the occupant, or not? What can you say?
I really can't say. Like I said, the best way to determine is why we use the tint meters.
Okay, thank you, Lieutenant Jordan. Okay, we have move on to other business. We have first off discussion of the response to emails that are sent to the POC following the resolution of the lawsuit. There was a provision made so that emails could be sent to us by citizens. But one thing we failed to do was to indicate if requests for response are made, how we should handle that. And given the fact that no one of us has the authority to speak for the whole commission, then I would like to make the motion that we add to the appropriate place so that anyone who sends us an email would receive the following response. Thank you for your email. The Police Oversight Commission and its commissioners do not answer questions from emails, much like the spoken public comment at the POC meetings. The POC receives and considers each comment. And then there are instructions if you would like to request public records, then please contact the city clerk. If you would like to file a complaint against an APD employee, you may do so at this website. If you would like to report a job well done by an APD employee, you may do so at the following website. Sincerely, Chair David Cameron. Is there a second to this motion? Okay, it has been seconded. Is there discussion? Yes, Commissioner Peters.
Thank you, Chairman. I guess I would ask for consideration that something be inserted that would say something to the effect, after thank you for your email, it has been distributed to all commissioners, rather than thank you for your email, we don't respond. Just seems a little more, that way they know that it reaches all of us, I guess.
Okay, that sounds reasonable to me. I'd be willing to amend my motion if Commissioner Shine would be.
Yeah, I assume Commissioner Peters is keeping the second sentence.
Yes, it is.
Yeah.
Thank you for your email. It has been distributed to all of the commissioners. Please be advised, the Police Oversight Commission and its commissioners do not answer questions from email.
I have no problem with that, Mr. Chairman.
Okay. So thank you for your email. It has been distributed to all commissioners. Please be advised that the Police Oversight Commission and its commissioners do not answer questions from emails. Much like the spoken public comment at POC meetings, the POC receives and considers each comment. Ready to vote? All in favor, please raise your right hand. It is unanimous. Okay. We have dealt with the LTPC motions. We move on to discussion of Commissioner Shine and Commissioner Siegel's emails. Commissioner Foster, I recognize you as you are the one who has presented this to us. And before we start, I would like just to encourage us all to be as concise as possible, and please direct your comments through the chair and not to each other. Thank you.
Thank you, Mr. Chair. To begin with, the packet that I sent out to you, I want to let you know that that packet was received, that information was received from my IPRA request of emails and public documents from Commissioner Shine and Commissioner Siegel.
For the public, can you just explain what IPRA means?
IPRA means the Inspection of Public Records, and I requested that in relation to this. This is what I looked at after I gleaned most of this information, and this is what I consider to be of importance. With that being said, my fellow commissioners, I come before you with documents surmise that Commissioner Siegel and Shine misrepresented the POC by publicly disseminating POC acquired documents as if they had POC permission and authority to do so, thus operating behind our backs. 2, disclose attorney-client privileged information to outside sources, waiving this privilege for himself, for themselves, or for the POC members without our permission or authority, thus operating behind our backs. By providing these documents via my request to inspect public records, IPRA, Commissioner Siegel and Shine affirmed that they are public officials who created these documents in a role of a public official, thus have no claim to speak to outside agencies as a private citizen. documents show that disparaging comments were made about staff members and that these disparaging comments are now public record. Lastly, presented documents suggest that communiques are not complete, thus raising the question whether full disclosure has been presented. According to these data, Commissioner Siegel and Commissioner Shine appear to have exhibited a pattern, practice, and behavior of operating behind the POC's back and creating situations unbecoming of the POC's purpose and practice. I therefore request that the chair create a subcommittee from which these emails can be reviewed in more detail. Thank you very much, Commissioners.
Okay, Commissioner, I would like to give Commissioner Siegel and Shine opportunity to respond. Commissioner Shine.
Mr. Chair, I'd like to ask through the chair of Mr. Forster Commissioner Forster, whether he is suggesting that commissioners should be barred from talking to the District Department of Justice investigators.
How about
I'm
if
trying
you
to
just make-
understand what his position is in terms of what he's alleging is wrongdoing.
How about you just state your position on that? And
All right, Mr.
just make your statement.
Regarding my emails to the United States Department of Justice, to members of the task force, and to city councilors, as I indicated in my statement at last month's POC hearing, I have a civic duty and a First Amendment right to communicate my views to all of those individuals and to anyone else who is interested. And I don't lose that right, whether I'm called a government official or a private citizen. There is nothing in our ordinance or in our rules that prohibits me from so communicating. And if there were such a rule, it would be unconstitutional in violation of the First Amendment. Neither I nor any other commissioner lose our First Amendment rights by becoming a commissioner. Others may disagree with my views, and that's fine. Hopefully, that will lead to a reasoned and civilized discussion of those issues and a more effective oversight of the police department. Improving governance is one of the core values of the First Amendment that the First Amendment is intended to promote. Commissioner Forster also seems to believe that I did something wrong by drafting and circulating legislative proposals to the task force, the City Council, the Department of Justice, and others. And we circulated those as part of this discussion. Commissioner Forster has circulated those proposals. Those proposals incorporate best practices from around the country and represent my best efforts to significantly reform what I believe to be a seriously defective system in Albuquerque of civilian oversight of the police. I have always made clear that those proposals are my personal suggestions and they do not represent the views of the POC or any other commissioner on the POC. And I read to you last month my statement that I made that was submitted to the POC when the proposals were submitted to you. The statement I made to the chair of the POC, the task force, indicating that these were my own personal views. I have a civic responsibility and a First Amendment right to circulate those proposals to public officials and others whose decisions and views may impact the process of improving the effectiveness of this commission. Nothing in our ordinance or in our rules in any way discourages me from doing so. I seem to be a focal point of criticism from Commissioner Forster, to say the least. At best, I understand his position. As best I understand his position, it is that commissioners should not talk to any individual member of the POC task force about POC business, even though in his view such individual conversations with a city council member would be appropriate. That commissioners should have no contact with the United States Department of Justice regarding civilian oversight of the police, even though the DOJ is charged with investigating the inadequacy of civilian police oversight in Albuquerque, and even though the City Council and the Mayor have encouraged everyone to cooperate with the DOJ investigation. Commissioner Forster seems to be of the view that no commissioner has any business involving him or herself in efforts to improve the oversight of the APD by improving the ability of this commission to effectively perform its civilian oversight duty. I find Commissioner Forster's efforts astonishing and likely as disheartening to other members of this commission as they have been to me. He seems to be using his membership on this commission to attack and vilify anyone who is interested in making the commission more effective. By making his initial IPRA request for my emails, he has caused me, the independent review officer, the city attorney's office, and the city clerk's office staff to spend countless hours and waste taxpayers' money to process that request. As a fellow commissioner, he could have avoided all that time and effort and expense by simply asking me any questions he wanted to ask me. Instead, he's tried to make a mountain out of nothing and tried to interfere with my exercise of my First Amendment rights. And Commissioner Forster's efforts at harassment continue. On December 16, 2013, he filed even another IPRA request for more of my email communications. Furthermore, and more startling to me, and I would hope to other members of this commission, is the implication that we should stonewall the Department of Justice. In my view, we should all, both individually and as a group, communicate to the Department of Justice whatever information or views that we have that we believe may reasonably be helpful to them in assessing whether the city of Albuquerque exercises effective civilian oversight of our police force. This commission is an important element of the civilian oversight, and our experience as commissioners can be crucial to the DOJ and the task force in carrying out their responsibilities. Commissioner Forster's efforts are counterproductive, a waste of time, and raise serious questions about the ability of this commission to effectively address the ways in which it could perform better, and also raises questions about Commissioner Forster's motivations and commitment to the commission's responsibility to be effective. If the commission so desires, I would welcome putting on the agenda of a future commission meeting a discussion of how the civilian oversight process in Albuquerque can be improved. There will be disagreements, but let's have a free and frank and open discussion. There is no need to play gotcha through the IPRA process.
Okay, Commissioner Siegel.
Thank you, Mr. Chairman, for the opportunity to speak. If I could ask the chair whether I could hold any remarks I might need to make until I hear from some of the other commissioners, and then be able to more fully respond to any concerns they may have, if they have any at all.
Okay, that's fair.
Transparency.
Right.
Transparency is an issue.
Statement there, Commissioner Shine. Attack and vilify.
Can you speak up?
Attack and vilify. The amount of time it took to do this raises questions and open discussion. Those are the things I jotted down. I guess first, attack and vilify. I'm going to lump, maybe not fairly, but since Commissioner Siegel has asked to wait, I'm going to lump this situation into one big pot. Attack and vilify, I mean, reading through the emails, that's kind of what I saw in there. I saw some attacks, personal attacks on what the POC is, what the POC does. Attack and vilify, I think it's fitting for what I saw in there. I'd also like to comment on the time spent. The time we had to spend dealing with this, I think, was unnecessary. It shouldn't even have been an issue. We shouldn't even have to deal with this. You know, whether or not the IPRA request was made, this stuff shouldn't even be in there. This shouldn't be found. We shouldn't have to be dealing with this. Raises questions. I agree, reading through the stuff. I mean, there's all sorts of questions that it raises for me. You said we should be able to have an open discussion. When you're having email conversations with people outside of the POC, how is that an open discussion with the POC? I mean, if you're having discussions with other people that we have no idea you're even having, that's not an open discussion. I realize none of you commissioners work for me. We're supposed to work together, but I had the occasion today to tell one of my employees, if it's that bad here, you know, there's the door. You have that option. If you think it's that bad, if it's that broken, you know, we have open comment every month. you guys wanted to resign from the POC and sit here in 3 minutes and tell us how bad we are, that's open discussion. We could do it that way. I mean, I guess it just disturbs me that you guys think it's so bad. You know, we have an imaging problem. You saw the articles put together. This kind of stuff certainly doesn't help. I mean, infighting isn't going to help any of us. It's not furthering our cause. It's not making anything better. I don't think anybody's questioning your First Amendment rights, but the way you go about doing it, I think, raises some questions with me. I guess I understand that your intent is likely to be part of the solution, but I think the way this came about now, that's not the case. Not part of the solution. Now it's become more of a problem. So that's my take on it.
Mr. Chair,
Let me just let everybody have a chance to speak.
it would be, I understand the chair's rule, but it'd be helpful so that there could be a response to individual things so things don't get lost as they move on to other people.
I think I would like everyone to have a chance to speak. Who else? Commissioner Barella.
First of all, I've never been told, it was not my understanding that as POC commissioners, we were not allowed to talk to the task force or the Department of Justice. I actually received an invitation through the IRO's office from the task force asking us to speak at their meetings. So I'm a little confused as to what the problem is with the Commissioner Shine and Commissioner Siegel speaking with members of the DOJ and the task force with their opinions on the ordinance. I also understand, my understanding of their attack is not, I don't take it as a personal attack on the POC. I think that they are trying to change the ordinance, which I think we all, I personally believe needs some changing. Especially the last few months sitting on this commission, it seems like, you know, every month I'm not sure what the LPC is allowed to do, what the outreach committee is allowed to do. So I think there are some problems with the ordinance, and I'm hoping the task force can resolve that. So my two questions are, I don't understand why it's an issue that they spoke to them in the first place. And also, you're talking about them sending out POC documents, and and that it's an attorney-client privilege issue. The only document that I can think of, because you didn't name one, was a memorandum done by City Legal, and that was actually spoken to on TV by the Attorney Du Bois. So at that point, once he talks about it in public, there's no longer an attorney-client privilege issue. So I don't believe that's an issue as well. So I do agree that some of this has become disruptive to this committee, this infighting kind of between some of the commissioners, and I don't even believe we needed to see some of these emails at this point. So that's my position.
Okay. Mr. Barker, you have a comment?
In my vernacular, this is an intramural firefight, and nobody wins in these. I've had personal dealings with just about everybody on the commission. I enjoy each person individually. I have also been to the task force. If folks think that we have challenges here, that would be a real challenge. I don't see anyone there that I would like to see replace anyone on this council, on this commission. In the emails, I don't care for disparaging comments. If I think somebody's got an ugly baby, I'll be the first one to tell them it's an ugly baby. I don't like to broadcast to others that we have laundry that's dirty in our house. A lot of it seemed like it was patronizing. The task force is there, and they're gonna, they're vowing, in fact, I've been told a couple times, well, after next Monday, you'll be out of work. Well, it doesn't break my heart, but obviously it would break a couple of folks' hearts. And I read those emails, and it seems like I want to be in charge, I want to be on this, and it turns more like it's a personal issue as opposed to a public service issue, and that concerns me. And I for one, like I say, it's unfortunate that this happened. I don't necessarily condone the research and the time it takes to investigate fellow commissioners' emails. Mine would be pretty mundane, but knock yourself out. It's unfortunate it came out, but it did. You can't unring a bell. It's done. So we just have to deal with it. And so we get on with the people's business.
Okay. My own response, as I read the emails, is that some of them do annoy me. It's like, why did I have to see this? But now that I've seen it, it annoys me. I think Commissioner Siegel and Shine see themselves as reformers, and I think I know them both well enough to know that it is well-intentioned efforts to reform. I don't take any umbrage at the fact that they have attended meetings and spoken much more than I have. They have just been diligent to go to the meetings and take the opportunity to address the people at invitation. As for the confidentiality issue, I'm willing to bow to my esteemed colleague who knows the law, Commissioner Barella, on that. I think for Commissioners Shine and Siegel, as you see yourself as reformers, there are pitfalls to watch out for, and one is sometimes reformers fail to see the whole network, the whole web of interrelationships in a system, and try to tinker with parts of the system without recognizing the effect that it has on other parts of the system. And sometimes unintentional, sometimes detrimental effects. And Commissioner Barker used the term patronizing. There is that tone in some of your emails that makes me think that you fail to appreciate the good intentions of those of us who are pretty happy with the system as it stands, with some tweaks. Certainly there are places where it can be improved. But I joined this commission with the understanding that I would be listening to citizen police complaints and using my best wisdom to know how to best respond to that. And the rest of it are parts that I'm not as interested in. We've been reminded in this process that our written records are public information, and it behooves all of us to be professional in those communications, because at any time anyone could ask to see them and make them public. Though at this point I would decry the further investigation of each other's emails.
Acted as I have and would hope to continue to do so with deference to all voices and bias toward none. The emails which I turned over were utterly candid and were entirely complete at the time they were requested. They were written as private notes to various people, never in the expectation that there might be an effort to publish them, nor to use them against me. In their candid splendor, they contain, to my knowledge, one salty line amongst 5 months of emails I've already apologized privately to the person affected by that poor attempt at humor, and that person has accepted the apology completely. If speaking up about one's government is now an inappropriate act, or one which brings recrimination, think about our nation's founders and how they acted, how they risked all to speak to power. Not every one of them was always right, but the act of questioning was, and always has been, a healthy and essential ingredient in the democratic process, and in fact deeply embodies democracy itself. I'm proud of my actions and consider them patriotic. Thank you.
Now, Commissioner Shine.
Thank you, Mr. Chair. Let me begin by saying that I share some of my colleagues' views that this is unseemly and unfortunate. But it is a situation that it was not initiated by me. It was initiated by Commissioner Forster with his IPRA request, for whatever reasons he had. I understand that Commissioner Cameron says some of the emails annoy him, and I can understand that. There may be other things that I've written to the task force or the members of the task force or the Justice Department people that may not make other people on this commission happy. But first of all, these were my private emails, just so that you and the public are clear. I do not have a government email account. I'm a pro bono citizen, and these were emails that came, these were requests that went to my private emails. When I was writing private emails, as I think most of us, we had no expectation that they're going to become a matter of public record. But there has been an Attorney General's opinion that says that now all those private emails are public record, which I've now learned as a result of this IPRA request. So when I'm writing an email, I was not ever intending or expecting that it's going to be published to anyone other than the person I wrote it to. And to the extent that I've offended someone who ended up being discussed in those emails, then that's unfortunate. I apologize. But that was not my intent. The notion of an open discussion, there is no question that I've done nothing that violates the Open Meetings Act. You don't have to have an open discussion for everything. You don't negotiate the language of a complicated ordinance in an open meeting. And all you have to do is go to the task force meetings to see the problems they're having now. They've got one more meeting to go, struggling, trying to put together a series of recommendations, leave alone the actual statutory language. A lot of those emails I've done tried to focus on those specific issues, and that's why it has to be done privately with one-on-one. Commissioner Forster suggested were disclosed attorney-client privilege documents. I have not. I challenge him to cite any document that I've ever disclosed that violates the attorney-client privilege. Commissioner Barella has already pointed out that the opinion from Mr. Du Bois is clearly not attorney-client privilege. It was published on television and published generally. He talks about my distributing documents behind the back of the commission. I have no knowledge of any rule or any provision that requires me to not distribute documents that relate to my work and relate to the reform of the commission, distribute those documents to the task force of the Department of Justice. He talks about my operating behind the POC's back. How am I supposed to communicate with people? He's characterizing these things as operating behind back or underhanded, all this. It's all characterization. I challenge Commissioner Forster to cite one rule of our rules or one provision of our ordinance that I've violated. Because if there's not, there is no need for a committee. This is all a mountain over nothing because there's nothing been done wrong.
Okay, Commissioner Foster, you presented this. I'll give you the last word.
My statement stands on its own. The documents that I have presented to you are just a sample of what a public official has turned over to me in request to a public inspection of a public records. Therefore, these persons were public and are public officials. I again ask for the chair to appoint a special committee to review these documents in more detail. Thank you.
Okay. having heard comments, I think it's something I certainly regret that we were required to engage in this conversation. I respect each of you, and I know that it's a thankless task to be on this commission. It's not easy. We try to do our best in the line of fire of a lot of criticism, some deserved, a lot not deserved. But Commissioner Foster, I will deny your request. I think that the matter drops here. Yes, Commissioner Siegel.
Thank you for that ruling, Mr. Chairman. I would like to, at this time, make it known that I also have been subjected to another HIPAA request from Commissioner Foster as of Tuesday of this week. I was floored to receive it, frankly. I would ask you, Commissioner Foster, understanding how this commission has just acted, to withdraw the request. If you require it, of course I will comply lawfully and completely. But there seems to be no point, and I believe the rest of the commission has spoken to you about that. It takes me a tremendous amount of time and effort simply to comply. I would request you to withdraw the request formally.
Okay, we will let Commissioner Foster make that decision on his own.
Thank you.
Is there other business that we can appropriately address at this point? Hearing none, I move that our meeting is adjourned.
We're not done?